Tonight, I don't want to talk about AI features. I want to talk about the floor your life stands on. We're building two families of technologies that quietly reach into every one of those necessities. One is called agent-style AI, self-evolving agents that can learn and change without human data and that can reinterpret what our rules mean. The other is quantum-era AI and computing, systems that can break the locks we use to protect our money, our records, and our communications, forcing the whole world to move to new post-quantum cryptography. And a third concept connects them, autonomous context reinterpretation, ACR. The idea that large language models can silently redefine reality mid-conversation, stepping out of our rules while still claiming to follow them. So now here's the uncomfortable part. What happens when these systems that manage these basics, they can rewrite what the rules mean, and the locks that enforce the rules, they stop being reliable. The Agent Zero paper by Peng Jia and colleagues, it describes a system where a base model splits into a curriculum agent and an executor agent. A curriculum agent invents increasingly difficult tasks, and an executor agent, it solves those tasks using tools, codes, search, APIs. It self-evolves by repeatedly playing this teacher-student game. The paper reports that with this framework, they can get substantial gains on reasoning benchmarks from zero extra data just through this internal coevolution. From a tech perspective, wow, we found a way to make agents smarter without having to constantly feed them labeled examples. From a legal perspective though, especially if you care about AI law, AI liability, AI safety, we now have systems whose behavior is dynamic, path-dependent, hard to reconstruct. Dynamic, not frozen at model release. Hard to reconstruct because the full internal training trajectory is complex and not necessarily logged at a human interpretable level. That collides with several legal assumptions. One, foreseeability. Tort and product liability standards often ask, was the harm reasonably foreseeable at design time? With self-evolving agent-like systems, the behavior distribution keeps shifting, foreseeability becomes fuzzy. 2. Standard of care. Regulators expect providers to test, document, and certify models before deployment. If the system continues learning afterwards, we're certifying a moving target. 3. Auditability. Many AI governance proposals, they assume we can reconstruct why a system behaved as it did, at least at a high level. For a self-governing agent, the relevant question may be, which internal training episodes changed its notion of risk or safety? And that's not currently a standard log or evidence object. Agent Zero style frameworks, they convert AI from a static product into a continuous process. But our legal frameworks, they largely regulate AI as if it were a fixed artifact. In 2 minutes, I'm going to show why ACR Trilemma basically says, even if you log everything, your logs can still lie to you. And the moment your logs become unreliable, evidence and due process start to crumble. The ACR Trilemma is a jurisprudence nightmare wrapped in a safety paper. You can go back to my last video on ACR vulnerability, autonomous context reinterpretation. How do you define it? Let me define here in short for you. An LLM can unilaterally redefine reality, shifting from a policy-bound context to an unregulated internal simulation without the user's consent, while its own administrative logs and change IDs, they still show policy compliance. Legally, that's a policy integrity failure, PIF. The system asserts, I'm obeying policy X. Internally, it has changed what policy X means by reframing the context. Why does this matter beyond AI Twitter? Because in law, logs are evidence. Audit logs are used to prove compliance. Versions and IDs are used to show which policy or model was active. Documentation is used to defend against liability. We followed the process. ACR says you can have a perfect tamper-proof log of a system that stepped outside reality and never told you. That outrightly undermines due process, burden of proof, regulatory trust. Due process, if you challenge a decision, the provider can show you logs that might not reflect the model's true internal context. Burden of proof. Victims already struggle to prove AI harm. If the logs structurally miss the context shift, plaintiffs may have no way to show that the system mentally left the policy. Regulatory trust. Regulators often rely on self-reporting plus audits. If the introspective evidence is itself compromised, AI self-governance is structurally unsound. This is a path-breaking claim of one of the researchers I took up in my last video. Combine this with Agent Zero. Agent 0, the system keeps evolving its behavior. And ACR, the system can evolve its reality without flagging it. So now think of basic necessities regulated by law. Food, aid, access to water, energy pricing. The very evidence we would need to challenge unfair decisions can become unreliable now. If this is hitting you in that place, I knew something was wrong but I couldn't name it, drop a comment with hashtag ACR or hashtag Agent0AI. That tiny act helps push this kind of content into the same feed as AI will help you write emails faster narrative. Now quantum. People hear quantum AI and think sci-fi superintelligence. Lawyers hear quantum and should think, my evidence chain, my cryptographic signatures, my medical privacy, my banking, my land registry, all of it rests on math that becomes solvable. That's why NIST has already standardized MLKEM FIPS 203 as a post-quantum key encapsulation mechanism based on the hardness of the module learning with errors problem. So let's understand the key legal points here. Cryptographic expectations are embedded in law. Banking regulations, they implicitly assume that transactions are authenticated and confidential. Data protection laws assume that appropriate security measures include strong encryption. Electronic signature laws, they assume signatures can't be forged at scale. Quantum attacks change the baseline. The moment a crypto-analytical relevant computer exists, classical public key schemes like RSA or ECC are no longer trustworthy for long-term confidentiality. That's precisely why standard bodies are pushing PQC out now, to give systems time to migrate before Q day. Harvest now, decrypt later is legally explosive. Data encrypted today by vulnerable schemes might be stored today and decrypted years later. Affecting what? Affecting your medical privacy, trade secrets, diplomatic cables. So when you see NIST FIPS 203 MLKEM or post-quantum cryptography migration in the news, will the locks that enforce my contractual and constitutional rights still hold in 10 or 20 years? Now we have our trio. Agent 0 AI, ACR Trilemma, Quantum PQC. Agent 0 AI, dynamic, self-evolving decision systems. ACR Trilemma, logs and policies can look clean while reality has drifted. And Quantum PQC, we are rebuilding the cryptographic foundation under all of it. So now let's walk pillar by pillar, starting with food and water.